During a 6th grade choir class, an assistant principal allegedly ordered a mass, suspicionless strip search of the underwear of 22 preteen girls. All agree that the search violated the girls' constitutional rights under Texas and federal law. Even so, the district court dismissed the girls' lawsuit against the school district for failure to state a claim. We reverse. For the purposes of this appeal, we take as true the amended complaint's factual allegations. Those allegations describe how $50 went missing during a 6th grade choir class at Houston's public Lanier High School. Assistant Principal Verlinda Higgins was brought in to investigate. When no money turned up, the school police officer suggested that girls like to hide things in their bras and panties. Quote. Just pausing for effect. Higgins took all 22 girls in the choir class to the female school nurse, who strip searched them, taking them one at a time into a bathroom where she checked around the waistband of their panties, loosened their bras, checked under their shirts. The girls were made to lift their shirts so that they were exposed from the shoulder to the waist. No parents were notified despite the girls' requests. No money was found. Can I just shake my head for a moment? What? I'm like, seriously, how? In 2018, do we not understand that you must contact parents? That children have due process rights, and that you must contact parents, and probably even authorities, before you do a Fourth Amendment search? Are we kidding here? Yes, Blackleaf, how in current year? The Houston Independent School District allegedly permits its school officials to conduct invasive searches of students' persons, but provides no training as to how to do so legally. Instead, the employees are left to rely on the school district's written search policy as set forth in 3 official school district documents attached to the amended complaint. The first document, labeled Legal Policy FNF, states in abstract terms the federal legal standards governing student searches. It instructs that searches must be reasonable, and that a search is reasonable if it meets both of the following criteria. The action is justified at the inception, i.e., the school official has reasonable grounds for suspecting that the search will uncover evidence of a rule violation or a criminal violation. 2, the scope of the search is reasonably related to the circumstances that justified the search in the first place, i.e., the measures adopted are reasonably related to the objectives of the search and are not excessively intrusive in light of the age and sex of the student and the nature of the infraction. Legal Policy FNF also provides citation to the Fourth Amendment of the U.S. Constitution, New Jersey v. TLO, a case, and a federal district court opinion from 1980 dealing with dog sniff searches of cars. The document gives no further explanation or detail, however, as to what its 2 criteria mean or how teachers or administrators can tell when they are met. The policy also states that school officials may search a student's outer clothing, pockets, or property by establishing reasonable cause or securing the student's voluntary consent. Given the reference to outer clothing, this sentence could arguably be read to prohibit all strip searches regardless of context. The school district, however, emphatically rejects this view. At oral argument, for example, the following exchange occurred. The court. In the policy, where it says school officials may search a student's outer clothing, pockets, or property by establishing reasonable cause or securing consent, why doesn't that policy explicitly tell these teachers that they couldn't go beyond clothing, especially if they didn't even have reasonable cause? The school district. Well, unfortunately, in this day and age, there needs to be some discretion by school administrators that would allow those types of searches to maintain the safety in our schools. A second document, Regulation FNF2, sets forth certain implementing procedures. This document provides a simpler and broader rule for deciding when a search is proper. Students and their personal effects are subject to being searched by school officials if a school official has reasonable cause to believe that the student is in possession of contraband. If a school official has reasonable cause to believe that contraband is present, he or she may institute a search. The regulation further defines contraband as all substances or materials, the presence of which are prohibited by board policy or state law, and it briefly attempts to define the legal phrase, reasonable cause. The last relevant document is page 4 of the Student Code of Conduct. This briefly purports to describe the school district's legal policies and regulations. Its summary of the student search policy is further condensed. School officials are empowered to conduct reasonable searches of students and school property when there is reasonable cause to believe that students may be in possession of drugs, weapons, alcohol, or other materials in violation of school policy or state law. Students who bring contraband onto school grounds may be searched. Apart from inserting the quoted language into these 3 documents, the school district allegedly does nothing to apprise its employees of the standards that govern whether, when, or how public officials may constitutionally search a student's person or underwear. In wake of the mass strip search in this case, the school's principal issued a memo admonishing Higgins for requesting a search of the student's persons for items other than contraband. It is unclear why the principal did not consider stolen money to qualify as contraband under Regulation FNF2 and or the Student Code of Conduct, given that theft is prohibited by state law. Regardless, the supposed lack of contraband appears to have been the principal's only concern. The memo never criticized the search for invading the underwear of 22 preteen girls or for doing so without particularized suspicion. The memo likewise made no mention of legal policy FNF or Regulation FNF2. Instead, it instructed Higgins to follow the school district's policy and procedures in the Student Code of Conduct and to revisit page 4 of that code for policy procedures concerning school officials and reasonable search of students. The memo further made clear that, at least in the principal's mind, such strip searches of students are not per se improper under school district policy. Rather than forbidding all strip searches going forward, the memo requested, in the future, if you feel the need to have a search requiring a strip search, please notify me before proceeding. 2 of the girls' mothers sued the Houston Independent School District in federal district court on their daughters' behalves. They asserted claims under 42 U.S.C. 1983 and the Texas Constitution. This is basic civil rights law. 42 U.S.C. 1983 says that you can sue for a violation of your rights. As relief, they sought compensatory damages as well as an injunction requiring the school district to clarify its search policy and provide at least some Fourth Amendment training. The school district moved to dismiss the complaint for failure to state a claim. While its motion was pending, the school district responded to plaintiff's first set of interrogatories, discovery, and in doing so provided copies of the documents above. The district court subsequently granted the school district's motion and dismissed the complaint without prejudice. Plaintiffs amended their complaint, this time attaching copies of the school district's interrogatory responses and the documents the school district had provided. It was not enough. The district court granted the school district's renewed motion to dismiss, while denying further leave to amend. This appeal followed. We review the district court's dismissal de novo, accepting all well-pleaded facts as true and viewing those facts in the light most favorable to the plaintiffs. To survive a motion to dismiss, a complaint need not contain detailed factual allegations. Rather, it need only allege facts sufficient to state a claim for relief that is plausible on its face. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Significantly, a complaint may proceed even if recovery is very remote and unlikely, so long as the alleged facts raise a right to relief above the speculative level. The central issue on appeal is whether the amended complaint states a claim for municipal liability against the school district under 42 U.S.C. 1983. That statute makes liable every person who, under color of state law, violates federal constitutional rights. For this purpose, municipal entities, like the school district, qualify as persons. But the school district cannot be held liable under 1983 on a respondeat superior theory. Rather, the school district itself must have caused the violation. Thus, to state a 1983 claim against the school district, the amended complaint must allege sufficient factual content to permit the reasonable inference that a constitutional violation occurred, that an official policy attributable to the school district's policymakers was the moving force behind it. That the alleged facts demonstrate a constitutional violation is presently undisputed. A brief discussion of why the alleged search was unconstitutional will prove helpful. To search a student's person, school officials must generally have reasonable suspicion that the search will reveal evidence of a violation of school rules or the law. Reasonable suspicion has two dimensions. One is the knowledge component, which measures the strength of the evidence indicating illicit activity. The second dimension is the nexus component, measuring the strength of the evidence indicating that specific things to be searched for and seized are located on the property or the person. Together, these elements mean that the searching of a person requires a moderate chance of finding evidence of wrongdoing on the person of the specific student. When the search is of the student's underwear, moreover, additional requirements apply. Underwear searches are embarrassing, frightening, and humiliating. Both subjective and reasonable societal expectations of personal privacy support the treatment of such a search as categorically distinct, requiring distinct elements of justification. Strip searches implicate fundamental Fourth Amendment rights. Thus, the Supreme Court has made it clear that a search of a student's underwear is impermissibly intrusive unless school officials reasonably suspect either that the object of the search is dangerous or that it is actually likely to be hidden in the student's underwear. In Reading, a search requiring a 13-year-old student to pull her underwear away from her body was held impermissibly intrusive because no evidence suggested that the common pain relievers sought were either dangerous or likely to be found in the girl's underwear. Applied here, this clearly established law means that Higgins violated the constitutional rights of the 22 girls unless Higgins reasonably suspected that the missing $50 cash either 1, would be found on that particular girl's person, or 2, would be found specifically in that girl's underwear, or 3, would pose a dangerous threat to students. For what are perhaps obvious reasons, the parties do not dispute that the alleged search failed on all 3 conditions. It was clearly unconstitutional. The parties' real dispute concerns whether plaintiffs adequately allege an official municipal policy on which 1983 liability may rest. To be clear, the argument is not that the school district's written search policies are facially unconstitutional or that they caused the alleged constitutional violation by themselves. Rather, the official municipal policy on which plaintiffs attempt to hang Monell liability is the school district's alleged policy of providing no training whatsoever regarding its employees' legal duties not to conduct unreasonable searches. In other words, as currently presented, this is a failure to train case. The Supreme Court established the failure to train method of proving municipal liability in City of Canton v. Harris. Under Canton, when a municipal entity enacts a facially valid policy but fails to train its employees to implement it in a constitutional manner, that failure constitutes official policy that can support municipal liability if it amounts to deliberate indifference. To prove deliberate indifference at trial, plaintiffs must show that in light of the duties assigned to specific officers or employees, the need for more or different training is so obvious that the inadequate policy is so likely to result in the violation of constitutional rights that the policymakers can reasonably be said to be deliberately indifferent to the need. Canton envisioned 2 means of providing deliberate indifference. Sometimes, Canton said, municipal employees will violate constitutional rights so often that the fact finder can infer from the pattern of violations that the need for further training must have been plainly obvious to the policymakers. This proof by pattern method is ordinarily necessary, but absent proof of pattern, deliberate indifference can still be inferred if the fact finder determines that the risk of constitutional violation was or should have been an obvious or highly predictable consequence of the alleged training inadequacy. In a limited set of cases, a plaintiff unable to show a pattern of constitutional violations may establish deliberate indifference by showing a single incident with proof of the possibility of recurring situations that present an obvious potential for violation of constitutional rights, such that it should have been apparent to the policymaker that a constitutional violation was the highly predictable consequence of a particular policy or failure to train. Such an inference is possible in only very narrow circumstances. The municipality must have failed to train its employees concerning a clear constitutional duty implicated in recurrent situations that a particular employee is certain to face. Thus, for example, if a city policymaker opts to provide no training whatsoever to police officers concerning the established and recurring constitutional duty not to use excessive deadly force, a fact finder may reasonably infer that the city acted with the requisite deliberate indifference. The Supreme Court explained in Canton by way of hypothetical. City policymakers know to a moral certainty that their police officers will be required to arrest fleeing felons. The city has armed its officers with firearms, in part to allow them to accomplish this task. Thus, the need to train officers in the constitutional limitations on the use of deadly force can be said to be so obvious that failure to do so could properly be characterized as deliberate indifference to constitutional rights. Under those circumstances, there is an obvious need for some form of training. Otherwise, the Supreme Court has said there would be no way for novice officers to obtain the legal knowledge they require to conform their behavior to their clear and recurring constitutional obligations. You with me so far? This is some seriously cool stuff we're going over here about how your rights matter when the government is involved, and when the government is allowed to say, no, you get searched, or your kid gets searched in school, or whatever. These are the rules that talk about your rights, which is why I'm super interested in it. And now we're going to get into the actual facts. Here, the alleged facts taken together and assumed to be true permit the reasonable inference, i.e. the claim has facial plausibility, that the risk of public officials conducting unconstitutional searches was or should have been a highly predictable consequence of the school district's decision to provide its staff no training regarding the Constitution's constraints on searches. Indeed, plaintiff's allegations mirror Canton's hypothetical in all material or relevant aspects. As in Canton, the constitutional duty of the individual officer not to conduct unreasonable searches is clear, with ample constitutional guidance for municipalities. Although the Canton hypothetical concerned the Fourth Amendment's constraints on seizures, whereas this case concerns its constraints on searches, the precise nature of both types of obligations is sufficiently clear in the law. Indeed, if anything, it is the duties with respect to searches that are defined with greater specificity. Student searches are governed by defined principles such as the need for individualized suspicion, the nexus requirement, and the limit on unduly intrusive means. Excessive force, on the other hand, turns on the totality of the evidence balancing test that requires careful attention to the facts and circumstances of each particular case and is not capable of precise definition or mechanical application. Because excessive force is sufficiently clear to ground failure to train liability, we hold the same with respect to the law of unreasonable student searches. As in Canton, the constitutional duty not to conduct unreasonable searches is plausibly alleged to arise in recurrent situations that a particular employee is certain to face. The alleged facts here fairly imply that conducting a search within the meaning of the Fourth Amendment, thereby triggering the constitutional duty, is among the usual and recurring tasks that at least some school district employees must perform. Most notably, the school district expressly vests search authority in all its school officials and notifies its students that their persons may be searched. And with respect to Higgins herself, the alleged fact that she was brought in to investigate, coupled with the disciplinary memo's anticipation that she might order additional strip searches in the future, makes plausible that the school district expected or even intended that Higgins would exercise her authority to order students searched. These factual allegations must suffice at the pleading stage to show that the school district knew or should have known to a high degree of certainty that Higgins and other employees would be placed in situations requiring knowledge of Fourth Amendment search law. Like the city in Canton, the school district cannot rely on its employees to come pre-equipped with legal knowledge, just as there is no reason to assume police academy applicants are familiar with the constitutional restraints on deadly force. There is no reason to expect that school district employees automatically understand constitutional restraints on searching a student's person. The contrary arguments presented to us fail to engage the applicable legal framework. For example, the district court's analysis turns on its erroneous assumption that, without a pattern of unconstitutional searches, the school district could not have been on notice of the need to provide some type of Fourth Amendment training. But in light of Canton, the Fifth Circuit recognizes an exception to the pattern method of providing deliberate indifference for cases in which a constitutional violation was the highly predictable consequence of the alleged failure to train. The district court never meaningfully evaluated whether that exception might apply here, and we conclude that plaintiffs plausibly allege it might. The school district, meanwhile, devotes wide swaths of its brief to asserting the facial constitutionality of its written search policies. Because these policies correctly state the law, the school district says unlawful searches could not have been an obvious consequence. The first difficulty with this argument is its premise. In fact, the school district's written search policies are, at best, incomplete guides to actual Fourth Amendment law, capturing none of the alleged search's constitutional defects. Although the policies describe the knowledge component of the reasonable suspicion standard, they make no mention of the requirement that there be reasonable suspicion linking the contraband to a particular student. And the policies are wholly silent with respect to the additional requirements for strip searches, that there be reasonable suspicion that the object of the search will be found specifically in the student's underwear or else be dangerous. If anything, the policies say the opposite. They appear to condone the use of strip searches to locate contraband, defined as any item violating school policy or law. But even accepting the school district's incorrect premise, this argument is still beside the point. Canton rejected the contention that only unconstitutional policies are actionable under 1983. Instead, Canton permits municipal liability when a concededly valid policy is unconstitutionally applied. In such a case, the policy that grounds municipal liability is the failure to train municipal employees regarding their constitutional duties if that failure amounted to deliberate indifference and caused the plaintiff's injury. Plaintiffs need not also demonstrate the invalidity of the written policies themselves. Only two portions of the school district's brief confront the Canton framework. Those portions assert that the risk of unconstitutional searches could not plausibly have been an obvious consequence of providing no Fourth Amendment training because, 1, the missing $50 unambiguously fell outside the written policy's definition of contraband, and 2, the Fourth Amendment case law is not void for vagueness. The relevance of the first point is unclear, but it is, in any event, incorrect. Because Texas law prohibits theft, the reportedly stolen $50 constituted both materials prohibited by state law within the meaning of Regulation FNF2 and evidence of a criminal violation within legal policy FNF. And the school district's second point is a non-sequitur. Nothing in Canton suggests that a legal doctrine must be void for vagueness before a municipality's failure to train its staff to follow it can ground a failure to train theory. Otherwise, there could be no Canton hypothetical. After all, police officers can always conduct their own research into excessive force law, which one assumes is not void for vagueness either. We hold that deliberate indifference is plausibly alleged. Of course, deliberate indifference is not the whole story. Plaintiff's failure to train theory will also require proof of cause. Would the injury have been avoided had the employee been trained under a program that was not deficient in the identified respect? Without stating its reasoning, the district court held that even if plaintiffs adequately alleged deliberate indifference, they also failed to allege causation. We hold otherwise. Given the relatively egregious nature of the alleged constitutional violation in this case, we think it plausible that even a modicum of Fourth Amendment training would have alerted Higgins that the search she ordered was unconstitutional. We think that it plausible that Higgins would not have undertaken the search had she known it was illegal. Thus, to the extent that the amended complaint plausibly alleges deliberate indifference, it also plausibly alleges causation. We cannot affirm the district court's alternative basis for dismissing plaintiff's federal claims. The order dismissing those claims must be reversed. In addition, plaintiffs seek injunctive relief. The parties and the district court have implicitly assumed throughout this litigation that Texas law recognizes an implied cause of action under which plaintiffs can sue to enjoin municipal policies that cause constitutional violations, even if those policies are not themselves unconstitutional. Without passing judgment on this matter, we adopt that assumption for the limited purposes of this appeal. Even with that assumption in place, however, the district court dismissed plaintiff's Texas law causes of action for failure to state a claim. It did so for two independent reasons, both of which were error. First, the district court dismissed the Texas law claims based on its previous determination that the standards of causation applicable to 1983 suits for municipal liability, plaintiffs failed to allege sufficient facts to indicate that the school district's allegedly deficient training of its employees was the moving force behind the constitutional violations. We have already rejected the district court's conclusion on this point. In fact, we have held plaintiffs do allege sufficient factual content to permit the reasonable inference that, but for the alleged failure to train, the alleged constitutional violations would not have occurred. And to the extent that the district court intended to rely on its conclusion that plaintiffs failed to adequately allege deliberate indifference, we have rejected that conclusion too. This stated rationale from the district court cannot justify dismissing plaintiffs' state law claims. Second, the The district court dismissed the state law claims because, in its view, what plaintiffs appear to be asking for is an obey the law injunction, which the district court thought would be too vague to give a reasonable person notice of what it would require. For support, the district court cited Rule 65D of the Federal Rules of Civil Procedure, which defines the required scope and content of district court injunctions. A general injunction, which in essence orders a defendant to obey the law, is not permitted by the rules. We reverse this determination. It is far from clear that Rule 65D can ever justify dismissing a cause of action at the pleading stage. Rule 65D governs the scope and content of injunctions. It does not purport to set a pleading standard. Neither the district court nor the school district cites any case suggesting that a complaint's failure to propose sufficiently specific injunction language is grounds for a 12b6 dismissal. To the extent that 65D can theoretically justify a pleading stage dismissal, moreover, we expect that it can do so only if there is no conceivable way to frame the requested relief in adequately specific terms. That is not the case here. Far from merely requesting that the school district be enjoined from violating the Fourth Amendment, the amended complaint seeks, in its words, injunctive relief prohibiting the use of strip searches at schools in Houston Independent School District until the written student search policy is clearly defined, the procedure is implemented, and they receive training. It is not difficult to imagine reforms to the school district's allegedly non-existent Fourth Amendment training program that the district court could conceivably order without running afoul of 65D. To take some easy examples, the district court might order that the written policy be modified to mention the nexus requirement, or it might order that some type of in-person training occur at least once for certain classes of employees. The district court's characterization of plaintiffs' requested relief as a mere obey-the-law injunction is incorrect. That is not to say that the language in the amended complaint would pass muster if copied verbatim into an injunction. In the event that plaintiffs demonstrate their entitlement to such an order, presumably after a trial, there will be opportunity for the parties and the court to resolve which particular requirements are justified by the established facts. But at the pleading stage, the rule that injunctions must do more than order the defendant to obey the law cannot justify the dismissal by the district court that they entered here. The district court's judgment is reversed. This case is remanded for further proceedings consistent with this opinion. Wow. I'm absolutely stunned that the school district would provide no training, and I'm stunned that the assistant principal, was it principal or superintendent, would just do this. Somebody's on a power trip, or somebody doesn't believe that people have rights, or somebody was really, really upset about their $50. I wonder if they ever found the $50. I'm gonna guess that they never found those $50. And that there's either some teacher out there who's like, I'm never gonna tell anyone that I found the $50 like 5 minutes after I lost it. Or there's some kid out there going, I can't talk about this for years. This is a community-supported channel. Join us at patreon.com/ljfrench. Many thanks to our July supporters. Thank you very much to Kareem Harper for supporting us at the $500 level. And thank you to the following $50 plus supporters: Jonathan Doe, John Steele, Gavin Barnard, Evie, Andy, Kyle Mudrock, John H. Anderson, Vera Mintain, Sean McNamara, William Gonzalez, Michael Pierce, Terry Crisp, and Grunkle Tia Marie. And thank you to the more than 210 $5 plus supporters scrolling on the panel behind me. All of your support allows us to focus on bringing you more and higher quality videos. I am Leonard French, your favorite copyright attorney. Thank you so much for helping us educate the lawful masses. See you next time. I think there's a little extra use of reasonable in there. Reasonable searches when there is reasonable cause. I think we conclude that the search is reasonable or not by determining whether the cause was reasonable or not. But okay.